Welcome to Easy Learning.
Exercise number 10. Cognizance of an offense and prosecution of an offender are two different things. Section 190 of the Code empowered taking cognizance of an offense and not to deal with offenders. Therefore, cognizance can be taken even if offender is not known or named when the complaint is filed or FIR registered. Their names may transpire during investigation or afterwards. Person who has not joined as accused in the charge sheet can be summoned at the stage of taking cognizance under section 190 of the code. It is also tried that even if a person is not named as an accused by the police in the final report submitted, the court would be justified in taking cognizance of the offense and to summon the accused if it feels that the evidence and material collected during investigation justifies prosecution of the accused. Thus, the magistrate is empowered to issue process against some other person who has not been charge sheeted, but there has to be sufficient material in the police report showing his involvement. Similarly, the magistrate is empowered to ignore the conclusion arrived at by the investigating officer and apply his mind independently on the facts emerging from the investigation and take cognizance of the case. At the same time, it is not permissible at this stage to consider any material other than that collected by the investigating officer. On the other hand, Section 204 of the Code deals with the issue of process. If, in the opinion of the magistrate taking cognizance of an offense, there is sufficient ground for proceeding. This section relates to commencement of a criminal proceeding. If the magistrate taking cognizance of a case upon a consideration of the materials before him, that is, the complaint, examination of the complainant and his witnesses, if present, or report of inquiry, if any, thinks that there is a prima facie case for proceeding in respect of an offense, he shall issue process against the accused. A wide discretion has been given as to grant or refusal of process, and it must be judicially exercised. A person ought not to be dragged into court merely because a complaint has been filed. If a prima facie case has been made out, the magistrate ought to issue process and it cannot be refused merely because he thinks that it is unlikely to result in a conviction. However, the words sufficient grounds for proceeding appearing in the section are of immense importance. It is these words which suggest that an opinion is to be formed only after due application of mind, that there is sufficient basis for proceeding against the said accused, and formation of such an opinion is to be stated in the order itself. The order is liable to be set aside if no reason is given therein, while coming to the conclusion that there is prima facie case against the accused, though the order need not contain detailed reasons. Epilogue. While parting, we make it clear that since on an erroneous presumption in law, the special magistrate has issued the summons to the appellants, it will always be open to the special magistrate to undertake the exercise of going through the material on record, and on that basis, if he is satisfied that there is enough incriminating material on record to proceed against the appellants as well, he may pass appropriate orders in this behalf. We also make it clear that even if at this stage no such prima facie material is found, but during the trial sufficient incriminating material against these appellants surfaces in the form of evidence, the special judge shall be at liberty to exercise his powers under section 319 of the code to rope in the appellants by passing appropriate orders in accordance with law at that stage. Full stop.